such as the right to equitable treatment by a public body in the execution of a function, such as the right to freedom of movement throughout Jamaica, such as the right to equality before the law, that is protection from arbitrary exercise of power, yes? Also, such as the right to privacy and protection of person and property. All of those rights, for example, they are not absolute, but they may be infringed on if Parliament or the body organ of state has demonstrated justifiable grounds in a free and democratic society. And I said to you that at the very least, that amounts to reasonable or probable cause. Okay? Now, but there's another thing I want to throw in it as I move forward. I mentioned to us all that there's a test that the courts use when it is trying to determine if some action taken by the state or a law passed by Parliament is constitutional, right? Because remember, if right can be infringed on. So the court has a test that is called the Oakes test. Google it, you will see it come up. Now, in the Oakes test, and in that Oakes test, the Oakes test says one of the elements in there is that for the infringement on a right to be constitutional, the action must be proportional. And proportional has a meaning. In its most basic form, when you're determining if some action is proportional, one have to ask themselves this question: is there a less intrusive way in which the right could have been infringed on? Let me repeat myself. For an organ of state to infringe on, abrogate, or abridge one of the constitutionally protected rights, a part of the test that the court will look at is called the Oakes test. One element of the Oakes test is that the court will look at proportionality. Is the infringement proportional? All right? So, and we said, proportional is looked at its most basic form to mean, is there a less intrusive way to infringe on this right? And let's look at that as quickly as we can. I continue to advocate and continue to make it plain and clear, not from my own mouth alone, but from Hemans versus the Attorney General, but from Indicom alluding to the police, everybody, the law, the Constitution, saying that a random stop for no justified reason is unlawful. It's unlawful because, like I said to you, the Constitution says that the infringement must be proportional for it to be constitutional. And that means it have to pass what we call the necessity test. Proportional test equals to necessity. Now, in that test, one of the key things that they have to look at is whether or not there is a less intrusive way to to achieve the objective that the law or the action exists. As long as there is a less intrusive way to achieve the objective of a statute or the actions that the public body, such as the JCF, want to take, then the Constitution says that action is not proportional. So diving into it a little bit more. For example, a random stop. There are less intrusive ways to achieve the objective that Section 20 of the Road Traffic Act might have. Because I know what the objective is. That provision that says you must have your license on you at all times, and when you are requested by a constable, you must produce it. The objective of that statute is to prevent people who don't have license from driving on the road, on the public road. That's the objective. Now, if the constables are saying, well, for us to achieve the objective of that statute, and by the way, I'm not saying that that's the only objective, but that's one of the main objectives of the statute. For us to achieve that objective, then we're going to stop random vehicle as we like. Remember, guys, we have discussed the equitable treatment provision already. Those are just joining us. We're just building onto that, all right? Now, if constables are saying that I am going to use that power Because one of the objectives of the statute in that